So welcome everybody to this webinar for Surrey Law Society members, a guide for conveyancers and litigators navigating properties let on an Airbnb basis in the UK. And thank you to Elizabeth England for 5Paper for presenting this. This is one of a series of training and events that the Society provides for its members, and I'm just sharing on screen now some forthcoming things that are happening. So we've got our Sailing for a Cure Legal charity event tomorrow evening on the Thames, an online course next week with Dan Warburton on 5 key principles to highly profitable delegation for law firm owners and partners, and the first in our Supporting Surrey series for this year, which covers financial well-being, and this first webinar is looking at a financial planning foundation hosted in collaboration with Evelyn Partners. Just some housekeeping for today. If you'd like to ask a question during the webinar, you can do this by typing it into the Q&A box or the chat facility if you prefer. If you'd like to speak to Elizabeth at the end of the webinar, please raise your hand and we'll unmute your microphone so you can do this. The webinar is being recorded and you will have a copy of that recording sent out afterwards alongside a feedback survey. We'd be ever so grateful if you could complete that just so that we can make our plans for the future. Okay, with no further ado, I'll pass over to Elizabeth. Thanks, Elizabeth.
Pleasure. Thank you for that. So hopefully you can see slides. I appreciate that this is a webinar for conveyancers, so I'm going to make it as relevant to conveyancers as possible, and also to litigators. And Airbnb, or short-term lettings, have provided a wealth of legal problems for both conveyancers and other litigators dealing with forfeiture and breaches of lease over the last 10 years or so, as Airbnb has become far more popular. And when I talk about Airbnb, I'm also talking about short lets, and those short lets might be advertised on booking.com or any other platform. I think Facebook Marketplace has seen advertising for properties on short lets. And in fact, I'm aware of Facebook lettings being used as advertising spaces for all sorts of short-term licensed and otherwise accommodations, which have caused trading standards to have a headache over the recent years. It has been revealed that there are areas in the UK where Airbnb affects 1 in every 4 homes. That's an astonishing figure. And we might in London also superimpose onto that a figure that about 30% of all social housing is unlawfully sublet on short lets, and various leases are being let in breach of lease on Airbnb. It's very difficult, unless there is nuisance, it is often very difficult to identify that properties are being sublet on this basis. So this growth in short-term lettings, you can see in this figure, 75,241 Airbnb listings in London on the 14th of March last year. I'm not sure what the equivalent figure was for this year. But the key concerns for those who are concerned about these things are that commercial operators have been using residential properties as letting businesses in breach of planning rules. And there are challenges to local authorities facing planning enforcement action. There's an impact on local housing markets, in particular on supply and rental prices. There are negative effects on neighbours and local communities in noise and disturbance and antisocial behaviour. Of course, Airbnb have got their own house rules about those kind of things. There are concerns about tax compliance and compliance with health and safety regulations, and implications for short-term accommodation businesses. So neighbouring hotels and bed and breakfast accommodation are finding those particularly challenging. For those conveyancers in the room, the tax compliance and various rules are actually quite interesting. For room only, if you like, so somebody is letting out just a room in their property, the tax implications are that HMRC have got a rent a room facility that allows somebody to earn up to £7,500 a year from renting a room. If there are joint owners, that's split between the two joint owners, so it's split 3,750 each. So it's a maximum of 7,500 for the unit, if you like. But if you rely on that rent a room, then you can't claim any expenses. If the Airbnb is for the whole property, so somebody owns a property or has a long lease over a property and they're looking to rent the whole, then they can earn up to £1,000 a year tax-free, and then the normal income tax rules apply and they can claim expenses on that. But you have to be aware of local limits on the number of days in the year that the whole can be let on a short-term basis. So in London, for example, there's a 90-day limit out of every year. Other areas of the country have got longer periods. People need to be VAT registered if they're earning over £80,000 a year on that. And in those areas of the country where you can sublet for more than 90 days in a year, then after 140 days, business rates apply. So there are various different corners for taxation if you're advising someone who's proposing to let a unit of accommodation as short-term lettings. It's not quite as simple as being able to short-term let through the whole of the year. There are also things to consider for the landlord, including that increased risk of damage to the property, the insurance implications for contents and buildings insurance, and as we're going to discuss later in this webinar, whether there's been a breach of the superior lease covenants. And that increased risk of damage can happen even if you're letting to business people. So it is common in London for business people to rent on an Airbnb basis for 2 or 3 nights in the week and then go home to wherever that is outside of London. Those 2 or 3 nights, you might be thinking, well, they're business people, they're going to treat the property well. I've heard anecdotally that doesn't necessarily follow. There might not be a hen or a stag party, but it doesn't mean that young professionals don't know how to party. There are, as I've said, 2 basic models for Airbnb lets, where the host stays in the property and just one room is let, and where the host lets the whole and stays somewhere else for those periods where the property is being sublet. And the word that we're interested and it comes up in the case law later is this word transient. It's a transient nature of occupation, and that transience translates to both the incoming Airbnb licensee and also the transience to the occupier. So, for example, if you've got a lease or subletting your whole home for 2 or 3 nights a week for a business person to be occupying, then you are yourself transient to the property. So that's an important thing to remember when somebody's asking about whether they can be occupying the property as a residence, and that's something that we're going to come back to. There are different types of Airbnb hosts. So you can host on Airbnb basically as long as you have a sufficient interest in the property. So Airbnb is interested in you having exclusive possession of your own property. So a licensee wouldn't be able to do so lawfully. I say that lawfully under the Airbnb rules. It might be that Booking.com or some other website has got a different rule, but under certainly Airbnb, they are looking at assured or short hold tenants, and that poses an issue for landlords, and sometimes it's proved a problem where a property is being sold to a let's call it a house on a street. It's being sold in a normal way, and the incoming landlord, if you like, the incoming owner, they buy subject to the encumbrances. It might be that somebody is used to Airbnb that property. The Airbnb is a license, so that they won't have permission to be there. If there's a assured short tenant sitting underneath the owner that hasn't been disclosed, and I've come across this in the last year, but only once, can happen, then you take subject to that tenancy. You then try and get rid of that person, obviously, and deal with the legal implications of it. But you then have to also deal with whatever contract they have with Airbnb, which can be it can be dealt with, but it's something just to iron out very, very quickly. And obviously then we've got a host with a long leaseholder of the property. This is what we normally see, because they're usually flats that are being underlet on Airbnb. Although if you're dealing with a house outside of London, then you're more likely to be dealing with a freeholder, so it doesn't really matter. So we're more interested in long leaseholders where there are restrictive covenants, and we're interested in assured and short hold tenants who also are subject to restrictive covenants. So there's a right to sublet to every lessee, whether they are an assured or short hold or long lessee. That right to sublet even extends to social housing, surprisingly enough. But that has to happen with the landlord's permission, and usually with the tenant remaining in occupation as their main or principal home, so they can have a lodger, and that is sometimes a way for the social housing tenant to make some money legitimately if they can't pay their rent. And that happens sometimes when they are under occupying their social housing. So it extends as a right to pretty much anybody, but there are usually contractual prohibitions, and they are absolute covenants against subletting the whole, and very often a part, and sometimes they are qualified. So they are often qualified so that you could sublet a part with permission, and that is at one end we see with social housing. But then in the leaseholder context, then you're looking at what the restrictive covenants are, and very often they prohibit subletting. Very often they demand, so there's a mandatory covenant or a positive covenant to occupy as your main residence, or as a family residence, or a prohibitive covenant, so it can run with the land, not to use it for any other purpose than your primary residence. And there are statutory restrictions on withholding consent, and that should not be unreasonably withheld. And then we're looking under assured or short hold tenancies about there's an absolute prohibition on subletting the whole, and that's under section 15 of the Housing Act 88, but you can impart with consent. The usual covenants under a long lease are not to use other than as a private residence. That's a common one, and that's the most commonly litigated and now most commonly understood covenant, and I'll come back to that. covenants against business users. I'm going to come back to this as well. Surprisingly, the court, or the upper lands tribunal, the upper tribunal, has decided that if you are Airbnb or subletting your property for 2 or 3 nights, that's not necessarily business use, but it depends on the facts. There are usually covenants not to vitiate insurance. Again, you need to look very carefully at what the insurance terms are for buildings and contents. And then covenants not to permit or suffer nuisance or annoyance. That again is subject to some interesting cases. I'm going to talk about 3 cases just later on in this webinar. And one of them is about whether somebody has permitted or suffered a nuisance when their short-term letting resulted in the property being used for prostitution, which is quite exciting. So here we go. Here's our 3 cases that I'm going to spend a short time talking about. The first was decided in 2016, Nemcova and Fairfield Rents. This was decided by the upper tribunal, came before His Honour Judge Stuart Bridge on the 6th of September 2016 about a breach of covenant not to use or permit use other than as a private residence. There we go. Not to use the devised premises or permit them to be used for any illegal or moral purpose or for any purpose whatsoever other than as a private residence. And this came before the first tier tribunal as a finding of a breach under Section 168 of Common Hold Leasehold Reform Act 2002. Now, these are, for those of you who don't often deal with the first tier tribunal, in order to forfeit a property, you first have to have a finding or admission, but you're looking for a finding of a breach, and if there is a breach found, then that gives rise to a right to forfeit, at which point you can elect whether to forfeit or not. The tenant, who's long leaseholder, let the flat through Airbnb for 90 days a year. This was a flat in London, so that was the maximum period under hosting rules. But it was otherwise empty for 75% of the year. And this was a trial over, or an appeal rather, over what use as a private residence means. Now, the upper tribunal looked at, reminded itself of Arnold and Britton. For those of you who don't know what Arnold and Britton is, Arnold and Britton is an absolutely excellent decision from 2015 involving a caravan park in West Wales. And the caravan park had been developed over a number of years, maybe 10 years, in the late 70s and early 80s. And the leases to the caravans, these are static caravans, the leases to the first wave of the development said that their service charges would increase by 10% every 3 years. And then a later batch said that they would increase by 3% every year. And whoever drafted that thought that the effect of the increase in service charges would be the same. But sadly, over a 99-year lease, it meant that those with the terms at 3% every year ended up increasing their service charges to the extent that after about 70 years, their service charges would be about £1.3 million per annum. And so they said that the terms of their leases were unenforceable. And the Supreme Court said you have to look at the ordinary meaning of the words in the lease, and they were stuck with that. Somebody should have applied their mind to exactly what 3% every year meant, and they didn't. And it doesn't mean it's unlawful, it was just a bad bargain. So the principles in Arnold and Britton are you have to look at the exact ordinary words, the ordinary meaning from the words used in the lease. And so what was said by His Honour Judge Stuart Bridge was that the covenant in this particular lease in Nemcova was that the explicit use of the words as a private residence does not refer to the word home, nor does it require the occupier in terms to use the premises as his or her home. It's important to be extremely careful not to gloss the terms of the clause so as to impose a requirement that was not intended. But fret not, it goes on. The clause does not state that the premise is to be used as the private residence of the lessee or the occupier, but as a private residence. The use of the indefinite article a is significant. A permanent residence that he or she calls home, as well as other temporary residences which are used while he or she is away from the home on business or on holiday. However, this is where it starts to look up, it's necessary in my judgment that there is a connection between the occupier and the residence such that the occupier would think of it as his or her residence, albeit not without limit time. The term private residence is a composite term. It may be intended that as room in a hotel is not a private residence. But if a guest stays there enjoying the facilities for months or years, a strong argument could be made that the room has become a private residence for the guest for the time being. It may be that where an occupier shared some part of the accommodation with someone else, it would cease to be a private residence, being a shared residence which does not have the attribute of privacy. That is, however, not the factual situation with which I am dealing. Reached the view, consistent with the decision of the FTT, that the duration of the occupier's occupation is material. So the occupier being the lessee. It does seem to me that in order for a property to be used as the occupier's private residence, there must be a degree of permanence going beyond being there for a weekend or a few nights in the week. In my judgment, I do not consider that where a person occupies for a matter of days and then leaves it, can be said that during the period of occupation, she's using the property as his or her private residence. The problem in such circumstances is that the occupation is transient. Is our word transient. So transient, that the occupier would not consider the property he or she is staying in as being his or her private residence, even for the time being. So what we're saying in Nemcova is that if the long lessee is proposing to sublet or is subletting for 2 or 3 nights a week for that 90-day period in London or any other period of time elsewhere, if that person's relationship with the property is transient itself, it doesn't matter about the transience of the people coming in, it's the occupier's transience we're worried about, then it's not being used as a private residence. What's interesting is there's another, if you were to read Nemcova, within that there is another case that's referred to called Caradon District Council and Patton, and in that's a case that was decided where the occupation of the flat as a private residence was equivalent of being a home. So it's important to think, is this where the person hangs their hat? Is this the place where the person is using that property as a primary home, if you like, rather than just using it transiently? And that's what private residence is. There was also an attempt to argue by the long lessee that use as a private residence meant it was capable of being used as a private residence. And for example, it had a kitchen, it had separate bedroom, living room, that kind of thing. So it had all the attributes you would expect of a private residence, as opposed to a hotel room, which might not have cooking facilities and that kind of thing. But the court said, no, it's not about that. It's not about the physical attributes. It's about the use of it. Now we've got this case, Triple Rose Limited and BT, decided in 2020. Triple Rose is a case that was decided by Sir Martin Roger, KC, or QC as he was then. Sir Martin Roger, for those of you who are familiar with the upper courts, is probably the authority on property law, and has made some very interesting decisions in the upper tribunal, which are almost always beyond refute. So his decisions are ones that we need to really put weight on. This case, the tenant had a 125-year lease over a flat in Newcastle, and the appellant, the landlord, was the long lessee. And the term, the covenant that we were interested in is this one: is not at any time to carry on or permit to be carried on the property any trade or business whatsoever, nor to use or permit the same to be used for any purpose other than as a private dwelling house for occupation by one family at a time. And Mr. and Mrs. Beattie initially used the flat as their home. It was their home in Newcastle. Unfortunately, I think Mr. Beattie lost his job. They relocated, but in order not to fall foul of the restrictive covenants, Mr. Beattie came back 2 or 3 nights a week, but otherwise the flat was advertised on Airbnb and Booking.com. They also used, to make it more attractive to people coming in, a third-party company for check-in, check-out, like a management company, and they also carried out laundry services. And there were 2 issues, going back to the covenant. There were 2 issues that were raised in the first-tier tribunal, and one was that it was said that they were carrying on a trade or business because of this third-party company and the laundry services. And secondly, that the property wasn't being used as a private dwelling by one family at any one time. Now, in the first-tier tribunal, the FTT said there was no breach of either covenant because Mr. Beattie was coming back. And so the head lessee appealed. And what's interesting is Martin Roger, KC, found no breach of the covenant for business use. He said there was no business happening on the property because the laundry services happened elsewhere and check-in, check-out happened elsewhere. That was really interesting. But he relied on the previous authority, the Fairfield authority, Nemcova in Fairfield, and said there was a breach of the second part of the covenant, that it wasn't being used as a private dwelling for one family at a time. So in terms of the business use, this deserves a little bit of consideration, because if you're advising somebody on whether they would be carrying out a business by a short let, there are nuances to what was said, so it's useful to have an understanding of why the decision was made. What Martin Rogers said, he was looking at the case of Tender and Sproul. It's a very old authority from 1947. And he explains what it is. The covenant in Tender and Sproul obliged a tenant not to use the premises or any part thereof for any business. And it was held that the taking in of paying guests constituted a breach of that obligation. In this case, it was not in dispute that the flat was being used for the business of short-term letting, but that business was being carried on from elsewhere, not upon the property. And those who were at the property were using it for residential purposes. In other words, the prohibition is against conducting business in the flat, not against using the flat for short-term residential purposes, albeit as part of a business. So if the business was being conducted in the flat, so advertising from in the flat, dealing with the check-in, check-out from in the flat, my view is that there would be an argument that the business was being carried on there, but that is very fact specific. So since no business was being conducted upon the property, no activity was carried on upon the property which amounted to a business. It's fairly straightforward. I consider that provision of laundry services between lettings, leaving breakfast goods for visitors and handing check-in and check-out do not alter that assessment and do not amount to carrying on business on the property, and therefore consider the FTT was right that letting the flat for short-term residential use did not breach the covenant against carrying on business. But it was a breach of the private dwelling house obligation. And it says the factors identified by the FTT do not seem to me to require any departure from the approach taken by the tribunal to the very similar covenant in Nemkova. If anything, particular language of the covenant in this case, with reference to dwelling house connoting settled accommodation and habitual residence, made this an even clearer case. On the facts found by the FTT, the individuals who occupied the flat for weekends or other short periods after responding to internet advertisements were not using the flat as a private dwelling house for occupation by one family at one time, by boasting that Mr. and Mrs. Beattie were in breach of their lease. So just pausing there on Triple Rose and Beattie, there's no business use, but they were in breach for not using it as a private dwelling. In the judgment, actually concluded with three things we need to keep an eye on, and drawing these two authorities together, these are the takeaways, I think. The first is that we have to look at the covenant. If we're looking at advising somebody whether they can let through Airbnb and whether they would be in breach of their covenant, the first is to look at the actual words of the covenant, because each covenant will be drafted differently, and each covenant will have different implications. So we're looking at the actual words. That's Arnold and Britton. What's the ordinary meaning of words? So the clever arguments that were being brought by the appellants, what is the private dwelling? It's got a kitchen. It's got these other facilities. That's too sophisticated. That's inviting the court to take too nuanced an approach. So we've got to look at the terms in their ordinary context and their ordinary meaning. And the other thing is, it's important to look at the context in which these covenants are being drafted. So, for example, if you're looking at a right to buy lease, so a lease that has been purchased by somebody through right to buy, that will have because it will have come from a social landlord, a restrictive covenant on subletting. And there's a statutory purpose for that. It is that these properties are sold at a discount, and they are intended to help somebody in their first home. And so they will not be allowed to sublet at all. And so they're wanting to use short-term lettings would be seen as an element of housing fraud, because they're not allowed to do it. So that's dealt with slightly differently. So we always look at the context of the covenant. You might be dealing with a development where there are mutual restrictive covenants that say each of these units to be used as a private residence only and no business use. And that will be because they don't want any business happening on the property, and they don't want short-term lettings. They want just all of the units to be used as homes. And so if you're trying to interpret or helping somebody to interpret a restrictive covenant, you also have to look at the context. You don't have to go through a contra preferendum rule necessarily, because you should be able to understand the covenant in its ordinary context. And if you can't, then it's worth taking some advice on it. And I think the third thing is each case is case specific. And what's interesting about the second case, the Triple Rose and Beattie case, is that I was surprised to see that the business use failed, because there was clearly a business that was being used for business purposes. But it's clear from the facts of that case that what came out during the trial was the business was being carried out elsewhere and not upon the property. I wonder whether the decision would have been different if the business was being carried out from the property. And so those are also things that are important to explore with somebody, asking for advice about whether they can carry out short lettings or whether they are, and you're, for the landlord, looking to see if there's been a breach. So each of these is fact specific, and that therefore it makes it a little bit harder to draw definite conclusions from these cases, other than I think it's now settled that a private dwelling house is actually used as a home, and the person who is meant to be living there has to be using it as their home and not as a transient home, but as their main home. Is it the place where they hang their hat? Is it the place that they send their bank statements and that kind of thing? Looking then at implications for insurance of property, it is very common for the tenants to covenant not to do anything on the demised premises which would render the landlord's policy of insurance void, or which might increase the premium on those policies. So these are also restrictive covenants that you would have to look at what the landlord's policy says, and whether subletting, if for the purpose of giving permission, if consent is being sought, whether it affects insurance. And that might come up, and often does come up, in the context of an unreasonable refusal to allow a sublet. Because remember, you can consent to subletting. So you'd want to have a look at the landlord's policy of insurance and see if it offended that, and you might want to make inquiries to see if the premium would increase or not. It is common now to see an extra obligation where you are proposing a short let, like Airbnb or Booking.com or something similar, that you would need to look at specific cover. It may well be Airbnb offers that facility itself, and some other platform might offer that that facility for insurance. You don't really want to look at guarantees. So there is a fundamental difference between a guarantee and insurance. You would want to be insured, and you want to make sure you don't invalidate your own insurance or anybody else's insurance. And again, evidence would be required to prove an increase in premium. So, so the evidence would be how often properties being let on Airbnb, whether it's within the rules and those kind of things. The next thing I want to talk about is nuisance and annoyance clauses. So it's common. It was a common worry for neighbours of those people who are neighbours to Airbnb short lets, that the accommodation is going to be used for hen parties, stag parties, other parties, lots of parties, general nuisance and annoyance. And it's common. In fact, I don't think I've ever seen a tenancy or a lease that doesn't say you must not suffer or permit anything that causes a nuisance or annoyance. Now, Airbnb allow house rules, and they restrict parties, and you can restrict in principle, but that's not a force field. It doesn't magically mean that people don't have parties. Authorising a party would be permitting a nuisance, potentially. And so that's something that would need to be considered if you're advising somebody whether they should or can sublet. If property is being used without the house rules, because that might attract more people, then they are potentially permitting a nuisance in breach of their covenants. Similarly, failing to make reasonable steps to avoid nuisance or annoyance might be suffering an act of nuisance or annoyance. So if somebody's aware, if the landlord is aware that their property is being used in a way that is causing a nuisance or annoyance to neighbours and they don't do anything about it, may well be a sufferance. It's a case of Marchitelli and 15 Westgate Terrace. I'm just going to tell you about, I haven't got a separate slide on it because it's a bit pointless, so I can tell you about it quite happily. Again, this is a decision of Martin Roger KC from June 2020. And the tenant was subletting to Airbnb. Airbnb, the Airbnb user was the same user over and over again, 2 or 3 nights a week, but that user was using the property for prostitution. And so that the particular user would basically come to the property with a prostitute every single time that person came to the property. And there was, in the first tier tribunal, clear evidence of prostitution. And I think there was some suggestion that there was more than one person using that property at one time again, and a suggestion that the owner should have or could reasonably have been expected to have known about the use of the property, and it was causing a nuisance annoyance to everybody else. The difficulty was that they couldn't prove that the person, the tenant, knew about the unlawful use of the property. And that became a problem at trial. So the first tier tribunal said, yes, it is being used for unlawful purposes, but it doesn't necessarily offend the nuisance or annoyance clause because the person isn't permitting or suffering any act, because they haven't permitted it and they don't necessarily know about it to suffer it. And in the absence of that evidence, on appeal by the landlord, Martin Roger refused to overturn that first decision. And so that creates an evidential point. So if there is a nuisance or annoyance, you don't have to just prove the nuisance or annoyance. They proved that. What they have to prove is that it was permitted expressly. It's very difficult to impliedly permit without it falling under sufferance. And suffering, it involves some knowledge. So you have to prove that the person knew. It's not enough that they should have known. So for the litigators in the room, what do we do about it? If there is unlawful subletting through Airbnb or shortlets, the first thing we can do is apply for a determination of breach under section 168. That's required before you can serve a section 146 notice. But you have to, in the context of forfeiture, the clock starts ticking as soon as you know that there is a breach of lease or potential breach of lease, because forfeiture is an election, it's a choice. And so if you choose not to do anything about it, but suffer it for a little while until it's annoying, then you may well waive your right to forfeit. And even if you get that determination of breach, then it may well be that time has passed. So you need to get that determination of breach as soon as you reasonably can. Then make sure that you're not doing anything, or I should say the landlord isn't doing anything to waive the breach. And waiver usually is, waiver is treating the lease as existing when you have elected to forfeit it. That's demanding rent, accepting rent, demanding service charges for a relevant period when the lease doesn't exist, basically taking any step. So you need to, at the point where the election is made, make sure that a line is drawn in the sand, and then you can go from there. The other thing you can do is in addition to, rather than, or as an alternative, apply for an injunction and damages. So the injunction would be to stop the breach of covenant, and damages would be for damage to the property. And for example, if the property is being used for prostitution, there is damage. There's damage to the value of the property as a property known for prostitution. So those are your remedies. I decided at the beginning of this talk to talk for about 45 minutes. That's the end of the slides. We are 45 minutes in, which gives us plenty of time for questions. So please do ask me any question. I'll just recap on what we've talked about. We've talked about problems with short lets, the tax implications, the insurance implications. We've talked about interpretation of the covenants, use of the property as a private residence, which is a common restrictive covenant, meaning a home, business use, and nuisance, and the remedies. So are there any questions? Okay, so Stephanie Newton asks, would use as a HMO, which is not transient but is an unconnected set of individuals living together, be likely to be treated as a breach of covenant to use a property as a single private dwelling in the occupation of one household? If it's being used as a HMO, then it would have to have an HMO license. And in order to obtain that license, then by definition, if there was a breach of covenant to use as a single private dwelling, that license wouldn't be given by the local authority. From my experience, I've seen that once before where the local authority said no because of that restrictive covenant. I suppose the other thing you could do is ask for a waiver of the breach of that covenant from the landlord in order to use it as an HMO. But I think that question is bound up in licensing. I saw a question come up from in the chat. Sorry. Could you, I'll answer it in the chat, but in order to keep it in the same place, could you put it in the Q&A? Hi, Elizabeth. What would the position be if a business is registered at the property? Would this be enough to breach the business use covenant? Not necessarily, because I could register my home address here as my business address and never work from home and always conduct business at another property. So the address is the registered business address sometimes is not indicative. And I've come across this a couple of times where a business has been registered at someone's address, but they actually carry on business somewhere else. So you would have to look at where the business is actually being carried on rather than where they say the correspondence address is. But of course, that you would also have to look at the covenant, because the covenant might actually be wide enough for you to capture the registry of the business at the address. But they usually say carry on business at. So it depends on where they're carrying on. Thanks, Molly. Does that answer the question? I would add to that, Molly. I have seen, in terms of a wide covenant, I have seen a covenant that says not to register or carry on any business at the address. So that would capture that. But it depends entirely on what the restrictive covenant says. Any more for any more? We've got another 10 minutes. Has anybody had a case that is that touches on these kind of issues that they've had difficulties with? No? Right, Helen, I think there's no more for no more.
Thanks very much, Elizabeth. And hopefully, I mean, if anyone did have any questions after the session, perhaps if they could forward them to me at Surrey Law Society and I might be able to pass them on to you, Elizabeth. Would that be okay?
Of course it is. Yeah, that'd be fine.
Lovely. Well, thank you so much for your presentation, which was really insightful, and thank you to everyone for joining us. As mentioned, we'll be issuing a recording of the session so that you can revisit it, and we would be grateful if you could fill out the assessment form at the end as well. With no further ado, I'll call it to a close and enjoy the rest of your afternoon. Thanks very much, everyone.
Thank you.